unlawful possession of a firearm as charged in count 2. And you elected to come to the court for punishment. Are both parties ready to proceed with this phase of the trial, State?
Yes, Your Honor.
Defense?
Yes.
All right, State, if you would read out the enhancements.
For count 1, before the commission of the alleged offense in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996, and cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery with a deadly weapon, the ZID gun. And before the commission of the primary offense and after the conviction in cause number 94 CR 5960 was final, the defendant committed the felony of assault family violence enhanced and was convicted on the 29th day of January 2013 in cause number D-1-DC-12-904040 in the 427th District Court in Travis County, Texas. For count 2, the state is alleging that the defendant is a repeat offender, and so before the commission of the offense alleged in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 in cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery, deadly weapon, the ZID gun.
All right. With regards to the enhancements in count 1, both enhancements, how do you plead? True or not true?
Not true.
Courtroom is set for a high-stakes showdown over sentencing. If you were sitting in those seats, what would you expect? Compassion or the harshest penalty possible? Clip 2. This is a pivotal moment.
As read for count 2, how do you plead?
Not true.
All right. Are there any opening statements from either side?
No, with the state will waive opening.
Waive opening.
All right, State, you may call your first witness.
Preliminarily, the state, Your Honor, the state would like to offer and admit all testimony and evidence that was heard in the Gilbertson's phase of trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well from the prior testimony.
And all the exhibits as well.
Yes.
Okay, then the state would also offer State's Exhibit A into evidence, pending any objection from the defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant and hearsay.
Yes. All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that State's Exhibit A is a self-authenticating document. However, with regards to whether or not this is connected to this defendant, then that objection will be sustained.
And Your Honor, if the state could respond, the state would respond that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating. But what the part of her objection that I'm sustaining is that State's Exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to somehow tie this document to this defendant.
Please tell the court what your area of expertise is.
I'm a fingerprint examiner for the Bexar County Sheriff's Office.
And do you have any, you possess any certification?
Yes, I have a certification in classifying fingerprints as well as identification fingerprints.
Please explain what those mean.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about fingerprints specifically. What is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found two different people to have the same set of fingerprints?
No, not to my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts. And we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our Henry classification that classifies the specific characteristics of the fingerprint.
Now, if that is your way of doing it, or is that the standard way?
That's the standard.
That's the what way?
The standard.
Can you take the witness on board diary?
Yes.
Okay. I may be a little confused. This exhibit B, when were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay. And so there's some other prints in the packet, right?
Correct. Here on the back of it.
Okay. But you were not saying you took those prints, right?
No, I didn't.
Okay. So you don't know my client, right?
No.
So you can say that the prints match, and you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken originally, correct?
No, ma'am.
And so you can't say you didn't witness that, who the person was who gave the prints.
Correct.
Correct. I would object to relevance and lack of affirmative link to my client.
All right. And so is the testimony,
I'm sorry.
was it established who these prints and State's Exhibit B were taken from?
I'm sorry, Judge?
Was it established who the prints were taken from in State's Exhibit B?
Yes.
You did test-
What individual? Do you want to, yes.
Ms. Valdez, you testified that you took the fingerprint states of the B today, correct?
Correct.
Do you see the person in the photo that you took those fingerprints from?
Yes, sir.
Would you please point to that person, identify him by an article of photos?
Will be the gentleman in the red.
You represent the record reflect that witness has identified the person that she took the fingerprints from in State's Exhibit B.
All right. Defense, any objection with regards to State's Exhibit A and B?
I re-urge the same objections, Your Honor. She has no knowledge of the person who gave the original prints.
All right. Those objections will be overruled. State's Exhibit A and B are admitted over defense counsel's objection. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes.
All right. As previously stated, the court is finding the enhancements true. And the court is finding the enhancements true that were read into the record for count 1, and also the enhancements true that were read into the record for count 2. The court will hear argument with regards to sentencing. Mr. Nicholson, you are not eligible for probation from the court. All right.
Yes, Your Honor. The state would like the court to consider State's Exhibits 39 and 40, which was entered in the guilt phase of trial. That's going to be the judgment from Austin for the conviction of assault enhanced, and additionally the fingerprint part that was linked to that judgment in the guilt phase of trial. Your Honor, this defendant does have a very lengthy and violent criminal history. In 1996, he was sentenced to 20 years for aggravated robbery. That's going to be cause number ending 60 that we entered in today. He was additionally sentenced for burglary of a habitation on that same day. That's going to be cause number ending in 59 that was entered into evidence today as part of State's Exhibit B. State's Exhibit A. Your Honor, he was sentenced in 1996 to 20 years in the Texas Department of Corrections for those crimes. When he was released, it was not very much longer until 2013 that he committed the offense in State's Exhibit 39 for assault enhanced, where he was convicted and sentenced to 6 years. So in 2019, after their 5 years are done, it took him only 3 years to commit this offense, this violent offense, where he shot at an unarmed Uber driver who just happened to be picking up his stepdaughter so that she could go to work. Thankfully, nobody was hurt in this offense, but that's just love, Your Honor. The capacity for this defendant to hurt people in this community and to hurt his family is shown by the criminal history, and the state is asking that the court sentence the defendant to no less than 40 years on count 1 and no less than 20 years on count 2.
Defense?
Thank you, Judge. I know that we've heard about his criminal history and the seriousness of it. I did want to offer some context to that, which starts with the fact that the first offense that for which he did the 20 years, he was actually age 16 when that happened. And he was certified as an adult and sentenced, and he ended up doing most of the time. He really lost so many of his formative years at doing that time, right? And then he gets released and is having trouble and has continued to have trouble adjusting. And the second case, the family violence assault case, he pled to, and he acknowledges, and I'm not saying he doesn't acknowledge the first case, but he does ask, and we do ask the judge to consider how young he was at that time. I have had contact with two of his family members, siblings, who are not able to be here today. One was a Mr. Paxton, and another is a sister, Samantha Romborg. And if I may, they both relate to me the chaotic and troubled childhood that they had, and how, in spite of what you see here today, that Mr. Nicholson was actually a loving and caring brother.
I'm sorry. Do you want those witnesses here?
No, I think we discuss it.
No objections from the state.
Okay.
That their father was a drug addict, and all the children in the family suffered tremendously, and that Dominic felt an enormous responsibility to try to provide for his siblings, which led him to make very poor choices to accomplish that goal, but that his actual motivation, and led him into down a criminal path, which I guess partly was role modeled by his father, but also his sense of duty and obligation to his siblings, and having very limited ability and resources to provide for them, in his overwhelming sense that he should try to provide for them, really hindered his thinking, and obviously has made extremely poor judgments. I know we stand here today, the jury heard the evidence and returned their verdict, but Mr. Nicholson believes that he can return to society and be rehabilitated. This has been a long, revolving door in his life that he is very tired of. And so we would ask the court to please sentence him at the minimum range.
All right. State, any final closing argument?
Your Honor, the state does appreciate that Mr. Nicholson was young when he committed the first offenses. However, I think that just speaks to his personality as prior life. And although the hopes for change are there, according to defense counsel, his actions speak louder than his words. And the court would like, the state would like the court to consider those actions, the harm that he could have caused on October 20th, 2022, and the harm that he has caused throughout his life.
All right. Is there anything you would like to say?
Yes, ma'am.
Here's the thing. If you want to say something, I'll take you under oath and the state will be allowed to question you. I mean, if you want to discuss it more with your attorney.
Life to be over like this, not being able to say anything, but I won't say
No, I mean, we can go off the record. Here's the thing. Once you decide to testify, and I think your defense counsel will tell you, there are certain appellate issues that may or may not be waived. So it's completely up to you if you want.
The judge makes it clear that the evidence is valid, but not yet fully linked to the accused. This back and forth over foundation and admissibility is a textbook courtroom tactic. So what do you think? Should technical rules shield the defendant, or should uncovering the truth always take priority?